A few years ago, a business owner came to me with a problem. He said, we had an agreement with a nonprofit to do work for them, and in exchange for that work, they would pay us $14,000. But after we did the work, everything was done, the nonprofit came back and said, how about we pay you $8,000? And the CEO said, well, I'm not sure I understand. Well, was there something wrong? The nonprofit said no. And the CEO said, well, why wouldn't you pay $14,000? That's what we agreed to. What are you talking about? And the nonprofit just said, we're willing to pay you $8,000. Is that sufficient? And the CEO said, no, we need payment of $14,000. The nonprofit said, well, if you want to get paid, you'll need to accept $8,000. The CEO said, well, that wasn't our deal. And they said, well, that's the deal now. If you want the money, you need to accept $8,000. The CEO said, well, that's not acceptable. We need the $14,000. And the nonprofit said, well, then you're not going to get paid. So the CEO came to me and said, what can we do about this? And I said, well, can I have a copy of the contract? He said, well, we kind of had a statement that we wrote up, kind of a statement of work, but there wasn't necessarily a contract. I said, well, send me whatever you have, because you had a deal. So that legally is a contract. What we need to see is what are the terms. Well, I looked at it. It very clearly said $14,000 in exchange for this work. I said, well, here's the problem. You are owed $14,000. You did your part. They didn't do their part. They owe you $14,000. But in order to hire me to sue them and go after that money, you're going to pay a lot more than what's at stake here. I said, you'd be better off accepting a payment of $8,000 than to sue them. And here's the problem. You'd like to recover attorney's fees, but in the United States, you can only recover attorney's fees if a contract says you have a right to do it, or if there's a special statute that allows you to do it. So I said, you could spend $15,000 to $20,000 in attorney's fees, but then you're only entitled to that $14,000 that you originally were entitled to. And so let's add up the money. Let's say you spend $20,000 in legal fees, and now you get $14,000. You're out $6,000. Whereas if you accept their $8,000 offer, you're ahead $8,000 compared to where you are now. Now, sure, you're entitled to $14,000, but if you have to go to court to get that money and have a judge rule that it in your favor, it's going to cost you some legal fees. And so it was at that moment that the CEO realized it's really important to have an attorney put together a contract with provisions that protect the CEO. So that's what we're talking about today. Contracts. How do we put together the provisions that are important to you? And part of that is just figuring out what are those. Now, of course, you can hire an attorney. And if that attorney sits down and talks with you about the deal and thinks about what pieces should be there, often the attorney will identify all these important provisions for you. But my hope for today is that you don't have to rely on the perfection of your business attorney, that you'll be able to identify for yourself what provisions should be there. You'll understand at the end of this section, what is a contract and how do I enforce it? And what are the different types of contracts? So we're going to talk today about what is a contract, what are the different types of contracts, and as we go through those, we'll talk about different provisions. These are just contract clauses, sometimes called terms, that basically you're saying, hey, we should have that in there, we should cover that subject. So a contract is just an agreement where both parties agree to do something or give up something. For example, I might say, hey, I'll pay you $100 to come paint my house. And you say, agreed. Well, I'm giving up something, $100. You're giving up something, the time it takes to come paint my house. Do we have a contract there? Yes. Now you might say, but wait a second. There are all sorts of terms missing. We didn't figure out what day, what color of paint to use. There's no agreement on how long it will take. And what does paint the house mean? Inside or outside? Well, courts have wrestled with these issues and basically said, as long as a reasonable person could imply those terms will be implied by a court if there's litigation. So, as long as there's a price, usually. Now you might say, well, are there circumstances when there doesn't have to be a price? Well, if the price is commonly known, like if the price is listed in newspapers like it is with commodities, or if the price is generally understood, like when buying and selling a vehicle, it's probably around the blue book value. But that's up to a judge to figure out what are the reasonable terms that should be part of a deal. So, what is a contract? It's when both parties are giving up something. And then you might say, well, does it have to be in writing? No. Generally speaking, oral or spoken agreements are totally enforceable. There are a few exceptions. These are the exceptions written in a statute. It's called the Statute of Frauds. And that Statute of Frauds says, you know what, for real estate transactions, for contracts for more than a year, for certain surety type agreements where one party's agreeing to be personally responsible for another party, for certain types of arrangements, it does have to be in writing. And there are even some exceptions to that. We're not going to get into that today. For most business contracts, an oral agreement is sufficient. So, of course, if you have something more than oral, like you have it in writing, that's even better. Now, the writing might be an email. It might be on the back of a napkin. It might be an invoice or a term sheet or some other informal communication. It really doesn't matter. The agreement is the exchange between the parties, and then whether it's by email or paper or recorded or on video or whatever that evidence is, that's evidence of the agreement. It's not the actual agreement itself. So even though we might talk about a legal document and we call it an agreement or we call it a contract, the agreement is actually the exchange that was approved by both parties, which is often reflected in a document. All right, so we don't have to get too technical about this, but I want to make sure you understand what is a contract. There's one other issue that comes up with what is a contract. What if I say to you, I will give you a brand new bike on Christmas, and you say, agreed. Is that a contract? No, because you didn't give up anything. It was a one-way deal. I gave up a bike, but that's a promise of a gift. It's not a contract. So keep in mind, you always have both parties giving up something. The legal term for that is consideration. In other words, both sides must have given up something, and that thing that's being given up, legally we call that consideration. You don't need to remember that term, but it is a legal term that's out there that lawyers will use when figuring out, was there actually a contract in place? So what I would think about is, was there an offer? Did the other side accept that offer? And did it involve both parties giving up something? Before we go too far, let's talk about some common contract mistakes. Well, we all know that COVID swept the world with a pandemic. And when that happened, a lot of people couldn't go to work. A lot of products didn't get shipped on time. A lot of things didn't happen. And as a result, contracts were breached left and right. A shipping contract was breached because it said it would deliver on a certain date. A manufacturing's contract to sell products that it was manufacturing was breached because the employees couldn't come to work. So what do you do when there are circumstances outside of your control, sometimes called acts of God? There's a special provision that you can put in contracts called force majeure. It's a Latin term. It essentially means an act of God or a force that was done outside of our control. What are some examples? Well, if your business burns down, or is flooded, or a pandemic happens, or a tornado hits you. A lot of these natural disasters, they qualify as acts of God or force majeure. And so you can have a provision in a contract that says, hey, in case of a pandemic, we are not required to perform under the deadlines in this agreement. Or maybe it says we can get out of the agreement if we want. So a force majeure clause often will say what parties have a right to do in circumstances that are outside their control, and then usually there's a list of those sorts of circumstances, and they're big issues: war, famine, tornado, etc. So one thing to think about is, do you want a force majeure provision in your contracts? Well, you might not want the other side to be able to get out of their obligations in case of a national catastrophe or an event or a pandemic or whatever the events may be. On the other hand, you might want the option to not perform under the contract. So one of the things to think about is, in each contract, do you want a force majeure provision? And then, what options does it give you? What options does it give the other side? It can give you options and not them, or vice versa. And sometimes, if you write up a contract that gives you options and the other side looks at it, they'll say, hey, we want those same options. As the old saying goes, what's good for the goose is good for the gander. So, one thing to think about is, do you want a force majeure provision? And if so, what should it say? You can think about that with every one of your contracts. So just like not having a force majeure clause is a problem in many contracts, another problem is a personal guarantee. Now you know the general rule, which is business owners are not contractually liable or not personally liable for the contracts of their business. So if you have an LLC and it has a contract with another business, your LLC is liable to perform under that contract, but you're not personally liable. In other words, if the LLC breaches the contract, the other side can't sue you personally and go after your house and your car. The other side can only go after your LLC. But there's a big exception to that. That is the personal guarantee. A personal guarantee is a contract provision where you say, hey, I'm willing to be personally liable for my business if it breaks this agreement. Couple common examples are a lease with a landlord. If you rent office space or space for your business, usually the landlord will say, hey, you're a small business. I'm not going to trust that your LLC or corporation will be around. So you need to sign a personal guarantee. Similarly, a bank will usually require you to sign a personal guarantee if you go to get a loan. So this bank says, yeah, we'll give your business a loan. It can have all that money. But if it doesn't repay it, the bank can go after you personally. So a personal guarantee is a very big exception to the general rule, which says you're not liable for your business. So think very carefully before signing a personal guarantee. I usually do everything I can to help my clients avoid having personal guarantees. But sometimes it's inevitable, in particular with landlords and with banks. You might be thinking to yourself, that raises an interesting point. If a landlord or bank sues my LLC, My LLC might not have much in it. Well, if they have a personal guarantee, they can go after me. But what about all those companies that don't have personal guarantees with me? That means they can sue the business, and unless your business has equipment or some other significant assets, it might not have a whole lot. And then you might say to yourself, well, wait a second. If that contract could be meaningless to these other businesses, maybe I need to worry about what if they breach their agreement and they don't have any assets. And you're exactly right. If you enter into a contract with a small business, and let's say you pay them a lot of money in advance, and then they go out of business, what happens if you try to sue them? Usually, nothing happens. You might win, but what do you win? You get a piece of paper from a court that says this LLC or corporation owes you money, and they don't have any money. They're not in business. So at the end of the day, you win nothing. So that's why it's really important for you to consider, should you have a personal guarantee from other parties? If they want to borrow money from you, if you are going to pay money in advance of getting products or services from them, maybe you want to consider a personal guarantee. Or you might want to consider making payments gradually in phases or milestones so that all of your money is not at risk right away. Because even though technically people can breach agreements, what does that matter unless they're enforced? And how do you enforce them? You have to go sue them. And that means paying money for legal fees. And often it means waiting a year for a lawsuit. So from a practical standpoint, it's not just enough to prove that somebody else breached an agreement. You often want to think about the practical side of how much would this actually cost to go after these guys, to sue them? How much time would it take? And if we win, assuming we will, how much are we really out? And can we really collect against them? Many, many times, clients come to me with a contract and we're talking about it, and I tell them, look, let's assume for a moment that they breach the agreement. And let's assume they don't have any assets, because we know most companies don't. As soon as the money comes in, it gets paid out to the employees or the owner as a profit distribution. Many companies don't have value. What are we going to do then? And so many times companies will say, I guess I don't want to pay in advance. I'll pay at the time I get the product. Or maybe I'll do 10% down. I'm willing to commit some level of risk. But I need some more assurances before I pay out a large amount of money. What's the takeaway here? First off, think about whether you should sign a personal guarantee. Usually you don't want to. Second, think about any time you do a deal with somebody, should they sign a personal guarantee? So that it's not just their company that's liable, it's them personally. And you can go after their personal assets. And also think about, in light of the fact that it is so expensive, time-consuming, and difficult to commence a lawsuit and actually recover the money owed, think about, are there any practical ways that you can avoid that scenario by somehow keeping some leverage, holding something back until you're ready to make that exact transition? And that's where a good attorney can help you. They can tell you what is standard in the industry. Sometimes you might even use something like an escrow service, because if both sides don't trust the other side, an escrow service is a third party where you can put the money and they can put the products, and then the third party releases both to the other party. For example, let's say you hire a manufacturer in another country and you decide you're going to pay them $500,000 to manufacture some products. But you don't trust that company. You want to make sure before they get the $500,000, you get the product, because it's too expensive and painful to sue them. So what do? you might consider using an escrow service where the manufacturer ships the products to the escrow company. You send the money to the escrow company. And once both are received and both parties can confirm everything looks good, then the escrow company releases everything and it goes off to the parties. So that's another option in making sure these contracts get enforced. So, practically speaking, it's not enough to have a great contract. You also want to think about, how do we enforce this? And are there practical ways to avoid getting burned, getting ripped off, or suffering as a victim from breach of contract? So when you're doing a contract with any other party, think about, if you got a judgment against them, if you sued them for breach of contract, would they have enough money to pay you? If yes, great, you at least have that possible recourse. If no, that party is called a judgment-proof party. What that basically means is, even if you got a judgment against them, it's worthless. It's meaningless. So, when thinking about contracts, it's not enough to have a great contract. You want to make sure you have a party on the other side that is not judgment-proof. Maybe you do that with a personal guarantee. And then also think about practical options like payments over time or some other gradual exchange of what each party is contributing to the deal, rather than a lump sum or all at once. Let's talk about independent contractors and employees. We're going to talk about the different types of independent contractors. But first, what is an independent contractor? Well, anybody you enter into a contract with is independent if they're not an employee or already in the company. So, if you have a contract, you can have a contract with an employee or somebody outside, and we call them independent contractors. So an independent contractor relationship is most other relationships. There are a few exceptions. For example, a franchise agreement or a partnership agreement. In those cases, it is outside companies, but you don't call them independent contractors. You call them partners or franchisors. But we'll set that aside for now. For purposes of this conversation, if your contract is not with an employee, it's with an outside company, that's generally going to be an independent contractor. Let's talk about that for a second, because you might be thinking, well, I have a graphic designer who works in my office every day. And that graphic designer uses my computer and comes in every day and has maybe an employee badge or maybe an email account on your domain. And you give that contractor training from time to time. This graphic designer, who you call an independent contractor, the law actually calls an employee. In most states, the state governments are very concerned about employers trying to avoid all the employment laws and obligations under the law as an employer by just calling the workers independent contractors. So think about it. Say you're an employer and you want to have somebody come work for you. It'd be really nice if you could just say, hey, you know what? I'm not going to treat you as an employee. You don't get all the employee rights, like the right not to be discriminated against, workers' compensation, payroll tax paid in part by the employer. Instead, all of that is on you. You're an independent contractor. You just provide services to me. The state governments throughout the United States have said, no, we're not just going to let employers call any worker an independent contractor. We're going to have a test. And I'm not going to get too deep into that test because there's a different test for the IRS than there is for the state. And every state has little differences. But let's look at it this way. If you hire an attorney, that's somebody who has their own professional expertise. They have a lot of clients. They have their own training, they use their own equipment, and they just come in for a little project from time to time. That's clearly an independent contractor. Similarly, you might hire a plumber. The plumber comes in and occasionally does a couple projects for you. But that plumber, in this scenario, has a lot of different customers, has his own equipment or her own equipment, and the plumber really manages herself. She does what's needed and just solves the big problem, but you're not there supervising her. For all those reasons, that plumber is clearly an independent contractor. But let's say now you have somebody who comes into the office every day, uses your computer. You supervise that person in detail. You say, hey, do it like this, not like that. You provide training to that person. That person gets a regular wage from you. That person doesn't work for a bunch of other customers. That person works for you. 100% of his wage or payment comes from you. That is very much like an employee relationship. So even if you call it an independent contractor relationship, the federal and state government will look at that and say, no, that's an employee. They are entitled to all the rights that other employees would get in your state and in your country. And here we're talking about United States. So that's rights against discrimination, certain obligations you have as an employer for payroll tax, and all sorts of other obligations you have regarding treating employees fairly, whereas you don't have to treat independent contractors in the same way. So now that we know what independent contractors are, let's talk about some common types of independent contractors. Well, in your relationship with customers and clients of your company, that clearly is an independent contractor relationship. We probably call you the independent contractor here, but you're providing some sort of goods, products, or services, some sort of labor or some other value. Whatever it is you're providing with customers or clients, that's going to be an independent contractor relationship. So that's one very common type of contract that we need to attend to. What are some important provisions that you should have in your contracts with your customers or clients? First, you might want to think about making sure you get paid. Now, if they pay you in advance, not a problem. We don't have to worry about going after them for unpaid payments according to your contract. But let's say, for example, you provide services or products and then they're supposed to pay you and don't. Well, we want to make sure that in the contract is an attorney's fees provision and a collections cost provision. Usually that's in the same provision or section. And it says simply, if your customer doesn't pay you, you have a right to sue for those payments and recover attorney's fees and collection costs that you incur in going after them. If you live in the UK, it's assumed, to my knowledge, that you're allowed to recover breach of contract attorney's fees. But in the United States, it's called the American rule. You need to have it in your contract if you have a right to recover it. Another important provision to consider for all of your contracts, but especially with your customers or clients, is an arbitration provision. Let's talk about what arbitration is. There's a federal law which says anytime parties enter into an agreement that their dispute will be handled by a private judge called an arbiter or an arbitration organization. Then any dispute will be handled there, not in a court. So essentially an arbitration provision is where the parties say, we don't want to go to court. We're going to give up all the protections and all the expense and hassle of going to a court. And we're going to have our dispute resolved in arbitration. Now, it's important to think about with each one of your contracts, is this to your advantage? Well, here's one advantage to having an arbitration provision. You can designate where the arbitration will take place, and which arbitration organization that will be. So you, for example, could pick your hometown, your city or county or town where you live. That gives you a convenient forum or venue in order to have any sort of dispute. One of the problems with an arbitration clause is your tax dollars pay for judges to resolve all the cases in court, but you've just opted out of that. You now have to pay the arbitrator to take care of your case. Both sides typically split the arbitrator's fees, and you're typically paying pretty significant fees because the arbitrator is an attorney, usually, sometimes a retired judge. And both parties are usually paying hundreds of dollars an hour for any work the arbitrator does. That includes looking at the documents ahead of time, listening to both sides, writing up a response or a ruling afterwards. So instead of your tax dollars paying a judge to do all of that work, you are now writing a check to pay the arbitrator fees in addition to the attorney's fees. In theory, arbitration can be less work for the attorneys. But frankly, that's not always the case. If one party wants to drag it on and fight over everything, your attorney is going to need to respond. And so practically speaking, arbitration can be just as expensive as going to court. So in a way, having an arbitration provision is somewhat an advanced consideration. But here's what I would think about. Who is likely to have to sue on this contract? For example, if the contract says, I will perform services and the other party will pay me $20,000. Am I likely to get sued? I think to myself, well, probably not, because I'm going to do a good job. But the other side, if they don't pay me, I'm going to have to sue them. So would I rather be in arbitration or a public court? By the way, one other consideration with that is all the documents in a public court are public information. So you might say to yourself, you know what? I don't want this sort of dispute in a public court. I want it in a private venue where all the evidence in that case cannot be accessed by third parties, like my competitors. So there's another advantage to arbitration, keeping the dispute private. It doesn't get filed in the public court records. Now, usually once it's done, a decision can get filed in the court records in order to enforce it. But what you will find many times is big companies will require everybody they work with to enter into contracts that have arbitration provisions in them. That way, it is not public knowledge if they're in a bunch of legal fights, because all of those fights are in private arbitration organizations. So as you can see, there's a lot of strategy as it relates to whether to have an arbitration provision in each contract. And many times, I'll recommend arbitration provisions in some contracts for one client, but not other contracts, because certain contracts we want resolved privately, and we want some of the benefits of arbitration and the disadvantages are not significant. Other times the disadvantages are too important, and we want this fight, if there is one, to be resolved by a court. So there are plenty of articles online about the pros and cons of arbitration. The goal today is to be thinking about, do your important contracts have an arbitration provision? And do you want there to be an arbitration provision in future contracts or the next time you renew or revise your existing contracts? Another type of contract that you might have is for services that you use. Now, this could be as simple as Google, Microsoft, Adobe for use of their software or software as a service. Or maybe you have a tech company come in and they help you with all of your tech needs because you've outsourced that. You don't want to have a full-time or part-time IT person on staff. Let's talk about that hypothetical. Let's say that you have an agreement that allows you 10 hours of IT support from a local tech company. That tech support company will come in from time to time and help with all of your computers. Here's one huge issue that most businesses don't attend to. They don't think about the fact that all of their business secrets are now available to a third party. Now you might say, but I don't care about that tech company. They have a great reputation. They're not going to share that information with anybody. But here's the problem. There is a very important law called the Trade Secrets Act, which says as long as you try to keep reasonably confidential information in your company, then ex-employees or others cannot share it without violating the Trade Secrets Act. But what happens if you don't try to make sure that you're keeping that information confidential with a confidentiality provision? In other words, let's say that one of your employees who didn't work out copies all of your data, leaves, and then goes and works at a competitor and shares all that data with them. Well, under the Trade Secrets Law, you would say, hey, that employee just stole all of our secret data. That's ours. You can't use that. That is our competitive advantage data. We kept this secret. We didn't put it on our website. We didn't make it known to vendors. We didn't let customers see it. The only people who had access to it were employees. But remember that IT contractor? They also had access to it. So what happens is in this scenario, let's say you sue your competitor for using all of your secret ideas and all of your secret data and all that data on the hard drive that your employee took. The attorney representing that company will need to try to prove that you didn't make reasonable efforts to keep that information confidential. The attorney will try to show that you actually had outside parties you were contracting with, like an IT company, and you didn't even ask them to keep it confidential. You didn't put any provision in your contract that it should be confidential. This scenario is very similar to cases that have occurred around the country. So, if it's important for you to keep information on your hard drives and on your server and in your emails confidential, there are a couple things you need to do. One, make sure there's a confidentiality provision in any contract for someone who has access to your confidential information. And then second, make sure that you let employees know that needs to be kept confidential. Maybe even label certain folders or files as confidential. The idea is the more you do to protect that confidentiality, the more evidence you'll have later to demonstrate that anyone who stole that information from you violated the Trade Secrets Act. So what's the takeaway here? Think about having a confidentiality provision in many of your contracts. You need to have it in all of the contracts where the other party would have access to information that you want to keep confidential. Let's talk about another type of service contract you might have. You may hire a designer. Maybe it's a web designer, maybe it's a graphic designer, maybe it's a software company. Let's use that as an example. There's a company who spent $100,000 asking a company to develop software for them. They paid them $100,000. They got the software. You might think, it's all good, right? But who owns that software? What you might not realize is that the general rule in the United States is if you hire a contractor to do something for you, They own the copyright, the intellectual property rights in whatever they design for you. Now, they might allow you to use it. But if you are paying $100,000 for some software code, you are probably assuming you own that. Now, if your employee wrote the code for you, then generally speaking, your company would own that code, as long as the employee did that as part of his or her job. But if you hire a contractor to write software code or music or do graphic design or prepare a website or whatever that might be, the general rule in the United States is the contractor owns the intellectual property rights in what they created. This even includes a photographer. If the photographer takes photos of your office space or your staff, under the law, the photographer owns the copyright to all of those photos. Now, there is something you can do about that. So here's the tip. Include a work made for hire provision in your contract with the independent contractor. A work made for hire provision basically says, look, this work that you're preparing was made by you for us, so we own the rights to it. That's what a work made for hire or a work for hire provision means. You can find it on the internet, but it basically says all copyrights acquired for this design or this software or photo or whatever it is are owned by us, not by you. So you can reverse the default rule simply by having in your contract with anybody who provides services to you a work made for hire provision.